What can you do after a divorce trial? Once the ruling has been handed down, if either party has any objections to the ruling, they can raise their concerns in a number of post-trial motions. It is important to note that along with the filing of a post-trial motion comes strict time windows to do so. In order to be heard, the post-trial motions should be presented within a timely fashion. If a party files a motion to reconsider, they are asking for the court to reevaluate the same facts of a case as well as the ruling handed down in the divorce. Common grounds for a motion to reconsider may include an alleged error or a claim that the law has changed. An example of this is in the Marriage of Willenberg. The Kansas Supreme Court approved a motion to reconsider because a mistake was made on the consequences that follow bankruptcy in regard to a property division. As stated, the motion asks for the court to reconsider the same facts, but that the motion may not be proper if the new evidence is necessary. While a motion to reconsider examines facts already presented, a motion for a new trial typically focuses on something outside the evidence presented. Although the presentation of new facts is generally required when requesting a new trial, a valid excuse for not offering the facts in a first trial is also required. Whether you are claiming misconduct by the opposing side or a substantial change in circumstances, the reasoning behind the motion for a new trial must fit into the grounds listed by K.S.A. 60259. Common grounds include new evidence not presented at a trial or a claim of prejudice. The district court difference between a motion to reconsider and a motion for a new trial is that a motion to reconsider focuses on one aspect of the judgment. A motion for a new trial begs to correct the entire matter because the ruling was flawed. In this case, a retrial may be necessary, whereas a motion to reconsider is a simple modification to the original judgment. Once a ruling is handed down, the parties have obligations that will result from the ruling. If a party is seeking relief from those obligations, a motion for relief from the final judgment may be filed. There are 6 grounds that encompass a motion for relief from a final judgment. First, if an error is realized beyond the allotted time for a retrial or reconsideration, then the error may justify relief from the final judgment. The same concept is also applicable when new evidence is uncovered. Third, if a party uses fraud, the opposing party may be subjected to relief from the court. Fourth, a party can be granted relief or he or she seeks to avoid a judgment that the court did not have the power to hand down in the first place. For instance, if a federal court grants a divorce, either party would be subjected to relief because federal courts are not permitted to rule on divorce proceedings. Fifth, if the obligation is satisfied or it's not fair for the obligation to continually apply, then relief may be necessary. An example involves a scenario of a remarrying spouse. In this scenario, spousal support would no longer be necessary. Last, the court may use any other reason to decide whether a party should continue to be bound to an obligation resulting from a divorce. If a party seeks to change certain parts of a divorce ruling, he or she may do so by filing a request for modification. Child custody, child support, and spousal support are allowed to be modified through this request. In regards to child custody, modification is suitable whether it would be greatest advantage to the children, and the parent can demonstrate a significant change in the situation. Examples that help support this modification may include the imprisonment of the custodial parent or a refusal of the custodial parent to respect visitation privileges. K.S.A. 233005 controls the modification of child support orders. Either parent can request a modification to the child support order regardless of who is ordered to pay child support. However, there are 2 criteria that one must keep in mind when seeking to modify child support. First, the child support order can be modified if the agreement was made more than 3 years ago. Because conditions are probably going to have changed in such time frame, a recalculation of child support owed is warranted. On the other hand, a modification may be necessary inside 3 years if a party can display a significant change in conditions. Examples of significant changes include changes in employment or changes in custody arrangements. Lastly, displaying a significant change in conditions can justify a modification of spousal support. Nonetheless, a spouse cannot be ordered to pay more than he or she was originally required to pay as a result of the initial ruling. The court can only lower the amount of spousal support based on a difference in circumstances. It is important to keep in mind that property division is typically something that cannot be modified through this motion. The thought being is that restrictions on the property division ought to be resolved at the time of the divorce in view of these conditions. Any adjustment in conditions is immaterial to conveying property obtained amid the marriage.